All right, guys, we're live for another Monday morning. Andrew's joined me again. We're talking about what happens when a collection agency or a creditor sues you when you're judgment proof. And all that really means is you've got a bunch of credit card debt, you can't afford to pay it, you have no assets that they can collateralize the debt with. Because what a judgment, why don't you explain it since you're the legal professional, Andrew? What is a judgment? Tell people.
Okay, so judgment is essentially just a legal term following a court-ordered decision that renders a debt owed to one party. So if you have a credit card and you haven't paid it, and that credit card company decides to initiate legal action against you, they have to go through the court process. And in that court process, an adjudicator, which is typically a judge or a deputy judge, makes a ruling on if that money is owed. And if the judge makes a ruling to determine that that money is owed, a piece of paper is furnished that says judgment in favor of X bank for X dollars. And then it's up to that creditor to try to get that money somehow from that individual. So that is what judgment is. It's a piece of paper that says one person owes another person money, and it's stamped and ordered by a court of justice.
So, I mean, to sort of clarify a little bit further, I mean, the way that I always used to sort of describe it is all that a judgment is it just gives the creditor a piece of paper that allows them to take the money that you owe them from you, right?
Yeah, in simplified terms, that's basically it. It's a piece of paper which allows a bank or a creditor to take the money from you in one of a few options. There are a few viable options for a creditor to take that money from you, which we'll discuss on this show. But that's
Let's deal with that right now. So what are the options?
Okay, so the options available to a creditor with that piece of paper, the judgment piece of paper, is they can put what is known as a lien against your property. That's the simplified term, lien, but the official term is writ of seizure and sale of land. And that official term is a scary term. I've had many clients get that notification in writing in the mail saying that a writ of seizure and sale of land has been filed. And when they hear the word sale of land, they kind of feel as though the land is being sold, beneath them, that someone has taken the land, but that's not what is happening. It's just the name of the document. But the term that we use as a simplified term is a lien. They put an electronic registered lien against your house if you own a house, so that way you cannot sell the house or refinance your mortgage without paying off that judgment balance first. And that's not a renewal. There's a difference between renewal and refinance. If you're refinancing your mortgage, which means you're going to a new lender or you're asking for more money out of your house, then you have to pay the judgment, same as if you're selling your property. So that's one of the options available to a creditor.
Renewal means nothing. It just sits there waiting for you to either sell it or to get a new mortgage from a new bank or financial institution.
Exactly. So it just sits
and they can go power of sale, right? It's just that they don't, because it's really not worth it. It's better just to get the judgment and then sit on it, collect the interest at whatever the court rate is awarded at, and get paid out when the house sells, somebody dies, they do some refinancing, whatever it is, right?
Yeah, they officially and technically they can proceed with power sale on the property. It's an extremely expensive process. And that's why most creditors, in fact, I've only seen it one time in 15 plus years where they've done this. So it's very rare for them to proceed with a power sale. It costs a lot of money, and most judgments are in the range of $5,000 to $20,000, give or take, most of them. And it's going to cost them well over $10,000 to proceed with the power sale. So it doesn't make a lot of business sense to throw extra money like that amount to try to recover a $5,000, $10,000, or $15,000 judgment. So it almost exclusively just remains as an electronic filing on your house. It sits there until the time as you pay that judgment off.
Okay, so they get a judgment. They can lien an asset like your house. They can garnish your wages. So that means they send a payroll garnishment to your employer, and they take a certain amount off your paycheck. What is a garnishment amount these days?
It varies from province to province, but that is the second option, and that is also a very seldomly used option from creditors in the judgment process, because if they're going to be taking people's money off their paycheck, then it makes them even more cash strapped. The reason why they haven't been paying to begin with is because they are cash strapped. So if you start taking that money from them through the court-ordered process of garnishment, a lot of those types of people that are having those garnishments will go to a bankruptcy trustee to file a bankruptcy to stop, lift, seize the garnishment, and that creditor will get nothing. So the garnishment process is extremely rare, but that is an option available to them. In order for that process to be functional, the creditor that has the judgment needs to know where that person works. You can't just throw a garnishment document up in the air and someone's going to catch it and say, okay, I'm going to garnish that person. Mm-hmm. They have to know where that person is employed. And then from there, they send that notice of garnishment, which is a court-ordered document, to the employer to say, we have a judgment in favor of XYZ Bank against XYZ consumer. We want the money to be garnished and sent to the sheriff's office, the local sheriff's office. Now, the amount varies to province, like you had said, or like you had asked. In Ontario, where we're located, the rule is 20%. So 20% of your income can be garnished, and it varies from province to province. Some provinces are higher, 30%. Some provinces are lower, where it's 15%. So it all depends on which province you live in, but it varies between 15 and 30%.
Okay, so those would be the main ones. There's another one where they can garnish your bank account. Is there anything else? And garnishing your bank account is, the same sort of thing. I'll tell you a little story. When I was in collections back in the 90s, there was this guy that used to work for me that he barely picked up the phone to call anybody to collect the debt. Instead, what he did was he was working this desk where I think they were called at the time sundry items, and basically this is where people would deposit an empty envelope in their ATM for $1,000, then they would make a withdrawal for $1,000, and then the bank would find out later there was no check in the envelope or there's no money in the envelope, and then they went after them for collections. And this happened a lot back in those days. I don't know if they still do this today, but this guy used to sit there, and because he had the right to offset the bank account because it's built into the entire legal process with that particular facility, he would just pick up the phone and call the banks and find out who had deposits, when their paydays were, and he would mark his calendar, and he would go through his calendar, and on paydays, he would call the banks, send the order to offset the funds from the bank account, and then just sit there and collect money from the bank instead of the debtor. It was pretty clever.
It is. It's actually, it works all the time too, that you're 100% successful with that. So that's actually a smart tactic. Very smart.
So offsetting money from a bank account, again, you can do that if you have a judgment or if there's a facility built into the arrangement, like into the contract that you essentially sign. Like if you deposit an empty envelope and there's no money in it, but you later make a deposit in the same account, they can offset it, sort of thing. But that's another way that they can take money in the form of a judgment. Generally speaking, most people that you're talking to, though, they're not a homeowner. Or if they are a homeowner, they don't have any equity, and all that means is there's like a value built up into the property that's not mortgaged. So they either don't have equity or they don't own a home. Like you stated earlier, to garnish somebody's paycheck is it's not the best move. It's like throwing good money after bad, because they can move. A lot of people don't stay in the same, like this isn't 50 years ago, like our parents and grandparents, where they'd stay in the same job forever, basically. Like people move around. A lot more people are self-employed today. So there's a lot of problems with that. So what generally happens when a collection agency, a creditor, a debt buyer, because debt buyers can sue people too, right? Like they can buy a bunch of debt from a creditor that they have up for sale for a few pennies on the dollar. They might buy $1 million portfolio for a couple cents on the dollar, and then they start suing people. So that's another option too. That's another source of judgment. So if somebody has nothing, what generally happens when a creditor sues somebody, that is basically what we call judgment proof, meaning you can't do anything with the judgment. It's just like another useless piece of paper.
Yeah, sure. I'm just going to take a step back because you covered off on the bank account and how a bank can offset from a bank account with a judgment. And I just want to talk off on how unlikely that is. That's the least likely of the three options, because the same principle applies with the garnishment of the paycheck. You need to know where that individual banks in order to offset or to take the money from the bank account. And that is extremely hard to know unless the individual is, I guess, foolish enough to continue to bank at the same bank who holds the judgment. So obviously, I'm not going to name names, but if you're banking with Bank A and they have a judgment against you on a credit card product, well, they're going to know you're still banking at Bank A because they see your deposits going into the account. So they're going to know that's the case. So you got to be foolish to be doing that. But that's, again, one of the options. It's extremely rare. It's the rarest of the three. To address your question on the garnishment, the judgment proof status, realistically speaking, there is quite a few lawsuits launched in today's marketplace where the individual has no asset in terms of property and does not have garnishable income. Income is garnishable from an employer. It's not garnishable from a federal source or a provincial source. So in today's market with COVID, a lot of people have been laid off. A lot of people are still waiting to go back to work. A lot of people have changed jobs waiting for it to be recalled to work. So there are a lot of people in today's economy and marketplace which are deemed unenforceable and judgment proof. So they just sit there. The bank will sit there with their judgment and won't be able to collect on it. Now, it's a foolish decision on the bank's part to launch a claim against someone who has no recourse to repay, but banks feel the need to continue to launch lawsuits against those types of people regardless. I guess they're in the frame of mind of they're hopeful that that person at some point will be able to make restitution on the debt by being gainfully employed at some point down the road, or looking to purchase property also sometime down the road.
Okay. So nothing really happens. It's just a piece of paper that sits there on a shelf collecting dust.
Yeah, and to be honest with you, I had a conversation yesterday with a lawyer off the record on behalf of a matter that we were handling together. And I asked them off the record what was going on with this creditor, why they were unwilling to look at offers or an offer that was reasonable on the table on an individual that was unenforceable. That essentially, again, means no property, no income to be garnished, no bank account that will be able to touch because the individual is on a pension income, which you can't touch pension income as a garnishment because it's federally issued. I discussed why the bank was unwilling to do it. He said, he was laughing. He's like, honestly, man, I don't know. Again, off the record, he was talking very openly, very casually. He said, I don't know, man. He goes, the bank sometimes can do very odd things. He goes, I have my instructions. I have to do what the bank tells me to do. If you make an offer and the bank says no, he goes, I just can't supersede it. He goes, it is what it is. He goes, I get it. He goes, we've got a lot of files sitting here in our office collecting dust. And essentially that means just sitting there doing nothing. They've got the judgment and they can't do anything with it. And the bank doesn't want to take whatever it is that that individual might have been offering to repay. And it just sits there doing nothing. So it happens.
So, I mean, you've basically burned down your financial life and given them like basically what's left of the ashes. I mean, they have nothing to touch. And when you're saying government issued income, I mean, you're not just talking about retirement income, pension income. We're talking about welfare, unemployment insurance, like any source of income that comes from the state, right?
Yeah, disability. So in Ontario, ODSP, any other type of government issued income that you're receiving, child tax benefits, is untouchable. They cannot touch that income. The only income they can garnish is employment income from an employer. So, or rental income. But again, same principle applies that they need to know who the tenant is. They need to know the name of the person, and then they have to send the garnishment order to that person. And then because that person's an individual, are they going to even comply with the garnishment order? Possibly, possibly not. So it's not the same as when you're sending a notice of garnishment to a registered company, incorporated, a limited company, and something like that.
The judgment's still good for 7 years and renewable 3 times, or has that changed?
No, that's I'm not sure if that was a rule or reg back in the day. Reg is regulation. Judgments are good forever. They don't expire. You have to renew your judgment against a property, which was that writ of seizure and sale that I discussed earlier. Every 5 years, I believe it is, maybe 6, but I'm pretty sure it's 5.
What's the cost for the renewal?
The renewal is probably the same cost as the issuance cost to file the judgment or the writ against the property. And I believe that's about 110-ish. So, but I don't know the sequence, how creditors work. I would highly doubt they have a calendar system which reminds them after 5 years to renew that judgment. They have to go and renew it.
I would imagine that there are costs to get a judgment, even in small claims court. It's going to be, even with a discounted volume rate with a law firm or a paralegal, is probably going to be $1,000 or $2,000. Then they've got filing fees for a couple $100, and they've got renewal fees for a couple $100. They could very well throw a few $1,000s after somebody that's judgment proof for a $10,000 credit card that they'll never collect the money on ever, right?
They could, yeah, and I've seen that. I've seen things as foolish as a creditor suing someone for a balance of $1,100, and I thought to myself, "Are you really doing this? $1,100 claim?" The reason why I say that's the example it's foolish is because that creditor has to pay. It's about $200 to launch a claim if you're a frequent filer in Ontario, and most creditors are frequent filers of claims because the banks are huge. So you're paying $200 to issue a claim. You're paying about $60 to $80 to serve the claim. You're paying representation costs for the individual, the law firm you've hired, to draft paperwork and to attend the matter. Then you're paying monies to set it down for trial. You're paying money to obtain judgment. You're paying money to register a writ of seizure and sale of land against the property. You're paying renewal fees. And all that makes no sense when the court can only award 15% in representation fees. So on that $1,000 claim, that bank can only get $150 back in representation fees. It's ridiculous. It's so some creditors that sue for such small balances, I look at the claim and I think to myself, that's a joke. You must be you must be kidding me to waste your time on an action of that size, that magnitude, when it's going to cost you 2 or 3 times the amount litigating. So it happens.
Yeah. Here, let me grab the ticker for TDF. So when it comes to that judgment, I mean, again, the difference between owing money and having a judgment is you just have a piece of paper now as a creditor that says that you can go and take the money. If they have a real asset, they can lien, sell, which they never really do. We talked about that. A paycheck they can garnish, or a bank account they can offset money for. So it's just another piece of paper saying that you owe the money, basically, right?
Yeah.
Are you still in a position to negotiate a settlement, even with a judgment?
Yes, certainly are. And that's exactly what we do. Even if there's a judgment rendered, I will certainly still negotiate a settlement with that creditor. Depending on the circumstances, will depend on what the result will be with the settlement. But I would say the average payout settlement on a judgment judgment debt, would be somewhere in the range of 45% on the low end to about 60 to 65% on the high end. So,
okay, so all that means is if somebody owes $100,000, they're going to pay out about $45,000 to $65,000 in total.
Yeah. And it all depends
on the work to do the negotiation on the settlement.
Yeah, it depends on their personal circircumstances. So the more bleak and financially bleak their circumstances, the lower the settlement.
Yeah, it's a hardship story. And like the other thing to consider too is like a settlement on the debt would be the ideal scenario, but you're also offering peace of mind. You're also offering the ability to manage, the creditor calls. You're also offering the ability to detour calls off the debtor from the creditor to you to handle the issue. And there's scenarios where a payout is not always possible at that time, maybe possible later on down the road, but there's a certain amount of peace of mind that you offer with that too, right?
Oh, for sure. Oh, yeah. I get a lot of feedback from clients that are extremely thankful for just me being, present and assisting them in this time in need. Some clients are more appreciative than others for obvious reasons. It's just, I guess, personality or whatnot. But a lot of clients are extremely thankful for the assistance that they're getting. They don't know how to navigate the system. They don't know how to navigate the paperwork. They don't know how to navigate the procedures in discussions or negotiations. So they're extremely thankful that they're getting the help that we're offering to them. And it's extremely viable service. And as you said, even if they don't have the money right off the bat, our program will accumulate that money for us to make the offer. And in the meantime, I've got processes and procedures in place that will assist reduce the interest rate, avoid garnishment. So there's all different things that we do to help assist our client avoid.
Complex.
Yeah, it helps avoid the garnishment and the legal process.
Yeah. All right. So let's just shout out and start to wrap this up. So you guys should be able to see the ticker below. If you have Canadian credit card debt, you don't necessarily have to live in Canada. You could be an expat living somewhere in Asia or the Middle East or something like that. But if you have a bunch of Canadian credit card debt and it's over $15,000 of debt, it's unsecured. If you're questioning that, just fill out the form and you'll get a quote. But fill that out. Go online to totaldebtfreedom.ca and you'll get a free consultation with one of Andrew's senior debt consultants. They'll take a look at who you owe and put together something that'll give you an idea of how much money you could potentially save and how long it would approximately take to get rid of that debt. But you're going to need to go to totaldebtfreedom.ca and fill out the form to get started on that. Anything else you want to add before we wrap up?
No, not really. I just people just need to need to know their rights. They need to learn the process, and the best way to learn it is to retain someone to explain it to them. It's very difficult for them to navigate it on their own, which is it's the same with anything else in life. If you're going to work on your car, you got to know what you're doing to your car. Otherwise, take it to your mechanic and let your mechanic work on it.
Yeah, and they don't want you to know, the global elites, the big bad creditors and all that. They want you plugged into lies. They want you thinking that you're vulnerable. They want you thinking that they're going to do everything under the sun to you. They're probably still bullies. I mean, I haven't been, directly involved on a day-to-day basis, but I'm assuming not a lot has changed.
Yeah, they obviously still want their money and they're going to bully their money back, and exactly what they're going to do. They're a little bit more relaxed now than they were obviously 20, 30 years ago, with different regulations employed and regulated by the governments, federal and provincial. So they have relaxed a little bit, but they're still very aggressive and they still want their money back.
Yeah. So, the banks and credit card companies have the big law firms and the lawyers and the paralegals, and, the smaller guys that have debt. You've got totaldebtfreedom.ca and guys like Andrew to, get your back on it. Let me just see if there's any questions here in the live chat we can grab before we go. It's just mostly comments. All right. Thanks, guys. Appreciate you watching the show. Give it a thumbs up just for the algorithms. And if there's a topic you want us to cover, just put it in the comments below and let us know what it is you'd like to hear us discuss in a future broadcast. We're live every Saturday at 9 a.m. Eastern Standard Time. Thanks, Andrew.
Thank you, guys.